A family history that once lived quietly in court files has now become the center of a criminal investigation, and the questions it raises reach far beyond a single household. Hit subscribe and turn on the bell to get first-hand updates on this case and other investigations as new facts are confirmed. Years before baby Emmanuel's disappearance drew national attention, a different, painful episode unfolded in the Haro family. Court records and interviews show that Jake Haro had been involved in earlier proceedings after an infant daughter required urgent medical care. That case did not end with a long prison sentence or permanent loss of custody. Instead, it resolved in probation and a set of court-ordered conditions. Today, that earlier outcome is under intense scrutiny. What once may have looked like a closed file now reads to many as an instance in a pattern, a point at which the system might have done more to protect children in that household. The specifics of that earlier proceeding matter because they shape how people see the present one. Probation is meant to be a tool of supervision and rehabilitation, but critics in this community argue it was not adequate given the seriousness of the allegations. For those who watched that earlier case, the idea that the accused remained in the community, with access to infants and young children, is chilling in the light of later events. That sense of unease is not merely emotional. It has prompted investigators to reopen prior files and prosecutors to look for connections they may have missed the first time around. Revisiting those files is painstaking work. Investigators are not simply skimming old documents. They are methodically assembling a timeline, emergency room notes, social work contacts, probation reports, court transcripts, and any informal complaints that may never have made it into a formal record. Each entry can matter. A medical entry noting unexplained bruising, or a caseworker's note about a missed appointment may be one piece in a larger mosaic of risk. Detectives are asking if warnings went unheeded, if required services were delivered and enforced, and whether the conditions of probation were monitored closely enough to keep children safe. That scrutiny has exposed, for many people, a profound unease about how the justice and child welfare systems operate in practice. Critics argue that the earlier sentence was too lenient and that probation did not adequately reflect the seriousness of the underlying conduct. They say probation can offer the appearance of intervention while leaving the root problems unaddressed. Probation is not a uniform experience. Its effectiveness depends on how conditions are enforced, how much contact is required, the availability of treatment programs, and the willingness of supervising officers to escalate when violations occur. When those pieces are missing or under-resourced, probation can be an inadequate response to harm involving a vulnerable infant. This critique is both practical and political. In court, plea deals and sentencing choices are shaped by the evidence available at the time, the judgment of prosecutors, and the discretion of judges who balance punishment with rehabilitation. Outside court, the community gauges those decisions by their outcomes. To parents, neighbors, and advocates who later saw another child harmed in the same household, the earlier disposition now appears, in retrospect, as a missed opportunity to prevent future danger. That retrospective judgment fuels a public demand for accountability, not only from the individuals accused of wrongdoing but also from the institutions that handled the case. Family testimony has become a central part of the emerging narrative. Margarita, described in court filings and media accounts as Jake's former mother-in-law, stepped into the public view with an emotional and detailed account of life inside the household. She described repeated patterns of control, monitored communications, discouraged visitors, and a kind of social isolation that left one family member, identified as Vanessa in testimony, cut off from outside contact. Margarita's testimony paints a picture of a home where decisions were concentrated in the hands of a single, domineering adult and where the ability to seek help, to call a doctor, to ask a neighbor for support, or to report a worrying incident, was limited by fear or by pressure. That kind of isolation is not a peripheral detail. It is a recognized risk factor in child protection work. When a caregiver is cut off from family, friends, and community checks, the informal safety net that most children rely on is absent. Neighbors who might otherwise notice bruises or a decline in health don't see them. Relatives who would intervene are kept at bay. In cases where one adult exerts strict control, the formal systems, doctors, social workers, and probation officers, must be particularly vigilant because informal checks may not be present to compensate for system failures. Testimony about restricted communication and household influence goes beyond anecdote. Investigators treat such accounts as leads that demand corroboration. Phone logs, text messages, and social media footprints can show whether contact with family members was reduced. Visitation records can demonstrate if outsiders were discouraged from calling or visiting, and interviews with other relatives may reveal a pattern of secrecy. When such patterns are found, they tell a story about the environment in which alleged harm occurred, an environment where help-seeking could be actively discouraged and where one adult's decisions shaped the choices of others in ways that may have masked real danger. Behavioral analysts have long stressed the importance of pattern recognition in cases of child harm. One isolated incident can happen, a series of episodes, multiple ER visits, inconsistent explanations for injuries, sudden changes in a child's weight or developmental milestones, signal something deeper. Analysts combine medical evidence, timelines, witness accounts, and environmental information such as housing stability, substance use, and social support to form risk assessments. In the Haro matter, patterns emerging from the earlier records and contemporary testimony point to a troubled household dynamic, repeated difficult situations, a lack of sustained oversight, and social isolation. Those patterns, analysts say, are the kinds of signals that should prompt escalation, not simply a single intervention that then quietly closes. Public reaction to all this has been raw and, at times, furious. Community members who believe prior interventions were insufficient feel betrayed. The emotional logic is simple. If earlier warning signs were not met with stronger protective action, then those decisions matter directly to the safety of future children. That anger translates into calls for reform, harsher penalties for child cruelty, clearer standards for when children should be removed from homes, and stricter enforcement of probation terms when infants are at risk. It also pushes policy debates about whether courts should have greater flexibility to impose protective conditions that limit an accused person's access to children while rehabilitation is ongoing. Officials who worked on earlier cases often push back on that public narrative by pointing to legal constraints. They say prosecutors must weigh the strength of evidence, the likelihood of obtaining a conviction, and the potential benefits of a negotiated plea. Judges decide sentences within statutory frameworks and balance punishment with rehabilitative aims that courts are supposed to consider. Nonetheless, critics maintain that when children's safety is involved, the balance should tilt toward preventive action. The Haro case has become an emblematic example of that clash between legal processes and the moral urgency of protecting children. Pressure on institutions is already evident. Investigators reopening prior files can trigger administrative reviews of how agencies handled earlier reports. If documents show lapses, such as unexecuted home visits, incomplete supervision logs, or missed probation check-ins, those failures can prompt internal audits, changes to training, and calls for increased resources. Child protection agencies, in particular, are asking whether their thresholds for removal are adequate, whether their follow-up mechanisms are robust enough, and whether cross-agency communication is sufficient to identify cumulative risk across multiple contacts. Policy advocates are proposing concrete changes. They call for improved data sharing between criminal courts and child welfare agencies so that a prosecutor's file is visible to caseworkers and vice versa. They recommend that probation conditions in cases involving infants include mandatory, documented home visits, proof of completion of parenting and anger management programs, and real consequences for missed check-ins. Others urge the use of technology, GPS monitoring, electronic check-ins, or telehealth visits, as supplemental tools where in-person oversight is limited by resources. Implementing any of these proposals requires funding, legislative action, and careful design to protect constitutional rights while enhancing child safety. Part of the story is also human and intimate. People like Margarita are not simply sources of incriminating testimony. They are relatives who feel they attempted to intervene and then watched as their warnings went unheard. Family testimony often carries with it a mixture of grief, guilt, and a desire for accountability. These voices tell investigators not only what happened but how the family felt constrained and unsupported. They also reveal the social dynamics that may have kept others silent. That human dimension complicates legal narratives because it introduces motive and context that are not immediately apparent from records alone. Prosecutors and defense attorneys both use such testimony strategically, but investigators treat it as essential context that helps explain why events unfolded the way they did. At the same time, investigators proceed carefully for legal and ethical reasons. Family recollections are powerful but fallible. Memory can shift, emotions can color perceptions, and interfamily dynamics can produce biases. Good investigative practice is to corroborate such testimony through objective evidence, phone records that show limited outside calls, bank statements that show unusual spending, medical records that show repeated injuries, or surveillance footage that contradicts a family member's account. In other words, testimony opens doors. Solid evidence is required to make the case stick in court. The legal landscape here is complex. If investigators find patterns linking past and present conduct, prosecutors may build a narrative of ongoing risk and intentional concealment. That narrative can support charges, enhance penalties, and justify more severe sentences. Defense counsel, predictably, will contest the interpretation of past records, argue that probation was appropriate at the time, and stress that prior dispositions do not prove guilt in the present allegations. The courtroom will be the arena where these competing stories are disputed and where judges and juries will be asked to weigh not just individual acts but patterns of behavior and institutional choices. Beyond the courtroom, this case feeds a broader civic debate about how society balances rehabilitation, punishment, and prevention. Some critics argue that the justice system too often favors plea bargains and community-based sentences because they clear court dockets and reduce incarceration costs. They say this cost-savings approach can have hidden human costs when it reduces the intensity of supervision for people with histories of harming children. Proponents of rehabilitation respond that prison by itself does not cure violent tendencies and that community supervision can be effective when well-resourced. The Haro case forces a practical question onto that theoretical debate. What structures and resources are necessary to make probation a protective, rather than permissive, option when infants are at risk? The policy implications are extensive. Lawmakers could consider statutes that require enhanced monitoring for individuals convicted of crimes against infants, or that set clearer standards for mandatory reporting and follow-up in cases of suspected child abuse. Child welfare agencies could be mandated to share risk assessments with courts at sentencing, ensuring that judicial discretion is informed by a fuller picture of the family environment. Probation departments might receive targeted funding to prioritize high-risk cases for more frequent contacts. Each of these reforms requires political will and budgetary commitments, but the moral argument for change is gaining strength among community members who now see a pattern linking earlier leniency to later tragedy. Amid all this debate, the human cost remains foremost. Emmanuel's disappearance is not an abstract policy puzzle. It is an absence felt by family and neighbors. The sense of loss is compounded by the bitter knowledge that earlier interventions existed and that people close to the family raised alarms. That emotional context fuels a relentless public demand, not only to resolve the immediate criminal questions, who is responsible and what happened, but also to ensure that institutional failures do not allow another child to slip through the cracks. Investigators continue to assemble their case with that larger purpose in mind. Re-examining prior files, they trace the threads that connect previous incidents to current allegations, timing of medical visits, the presence or absence of documented follow-up, and any evidence showing that supervision conditions were not enforced. They seek corroborating physical evidence where possible, medical records confirming unexplained injuries, communications showing restricted contacts, and data demonstrating missed probation appointments. The hope is to build a coherent account that not only answers the what and the who, but also illuminates the how and why, so that the legal resolution can be matched by policy lessons. Public pressure and media attention do influence the pace of administrative reviews and the urgency of legislative discussions. But investigators emphasize that thoroughness matters more than speed. Building a case that will survive legal scrutiny requires patience, cross-agency cooperation, and careful documentation. That is why authorities sometimes appear to move slowly, even as families and communities demand swift action. The tension between speed and rigor is the central challenge of any high-profile child protection inquiry. This case has also underscored the importance of community engagement in protective systems. Neighbors, relatives, and small business owners often hold pieces of the puzzle, a dashcam clip, a time-stamped receipt, or an otherwise ordinary observation, that can become crucial evidence when collected and preserved. Investigators repeatedly ask the public to share verifiable information with authorities rather than amplifying speculation on social media. Verified tips can focus resources and narrow search areas. Unverified rumors can muddy the waters. The community's role, investigators say, is not only to demand accountability but also to participate responsibly in evidence gathering. As the legal process continues, several clear lessons have emerged. First, prior probation outcomes in cases involving infants must be accompanied by robust, enforceable monitoring when there is any indication of risk. Probation should not be a passive state but an active supervision regime with clear standards and consequences. Second, patterns of household control and social isolation must be treated as significant risk indicators. Caseworkers and courts should probe not just for physical signs of abuse but for dynamics that can stifle help seeking. Third, institutions must do a better job of sharing data and coordinating responses so that isolated reports do not become layers of missed opportunity. At a policy level, the case calls for transparent review mechanisms after any incident of child harm, a formal after-action process to determine whether agencies responded appropriately and to recommend corrective steps when they did not. This kind of accountability is not meant to assign blame retroactively to overburdened workers but to identify structural gaps, resource shortages, unclear protocols, or legal constraints that can be fixed to prevent future tragedies. In the end, the Haro case is both an urgent criminal investigation and a mirror held up to systems of protection. The disappearance of a child forces a community to ask how earlier decisions, made with incomplete information and constrained resources, resulted in continuing exposure to risk. It is a reminder that justice has two goals in such cases: to hold individuals accountable where wrongdoing occurred and to reform institutions so that the same pattern cannot repeat. For now, investigators continue their work, reviewing files, seeking corroborating evidence, and preparing for the legal steps ahead. The public can help by providing concrete information and by pushing for thoughtful reforms. The emotions surrounding this case are raw and justified, but lasting change will come from meticulous investigation, careful policy design, and the political will to fund and enforce protective measures. This story, painful as it is, can lead to broader reform if policymakers listen to what the evidence and the families are telling them. Emmanuel's case should not be remembered only as a tragedy, it should also be a catalyst that strengthens how communities, courts, and child protection systems work together to keep children safe. Until then, the search for answers continues, driven by the twin demands of justice and prevention: learn what happened, hold those responsible to account, and fix the system so fewer families face this kind of grief.